Alleged mango markets exploiter Avraham Eisenberg is working to negotiate bail following his first New York court hearing Thursday. Eisenberg has publicly admitted to draining $116 million from the crypto exchange. He is in a jail until February 14th. Joining us now to discuss, we have Benjamin Bathgate. He's a partner at McMillan LLP, where he specializes in the fraud law group. Benjamin, thanks for joining us this morning. So there's some confusion over whether or not Avraham first waived bail or is now negotiating bail. Maybe you can walk us through what's going on.
Thanks, and good morning, Christine. Well, certainly it's a bit of a moving process. The actually first appearance was yesterday, so there's still a lot to be seen where this goes. They are putting bail over, so we're going to have to wait to see what happens next, if there's some negotiation on that, an agreement. But I think what we already know is that there's certainly a chilling effect in the DAO world. I think that's where things are going to get interesting to see how the reality of the CFTC coming, the SEC coming, civil lawsuits coming. I think it'll be interesting to see these next steps as the real world comes in an intersection with the online DAO world.
Just backtracking a bit, why? In Sam Bankman-Fried's case, we saw that, he had pretty good bail conditions. I mean, he was led straight to his parents' home. He, still has access to his phone. And whereas we're seeing Avraham Eisenberg here going ushered straight to jail and having to negotiate his bail terms. What's the reasoning behind that?
Well, I think certainly there's going to be more and more concern about flight risks. You're dealing with people who have, control over considerable assets that really know no bounds, know no jurisdictions. And people like in Eisenberg's case, and we've seen this before, certainly have no hesitation to get out on the online world and the chats and talk about the amazing arbitrage that was done, right? Code is law. This was just a good commerce move, and don't necessarily see this as being in any way offside or improper or illegal. So when you have some of those circumstances, the very fungible nature and that knows no jurisdictional bounds of crypto as well, it is a situation where there are concerns about the movement of those funds, where they go, and where that person may go. So I do think we're going to see more restraint and caution in that area.
And just as a refresher for folks out there, Avraham was part of the group that exploited the Solana-based DeFi lending protocol Mango Markets out of $114 million. And after pulling off the heist, which Eisenberg described on Twitter as both legal and a highly profitable trading strategy, he returned $67 million to preempt the Mango Markets DAO from suing him in civil court. That gambit didn't work. Eisenberg is currently being sued by Mango Labs for the remaining $47 million, and he's been indicted on 3 criminal offenses, including commodities fraud, commodities manipulation, and wire fraud. And in Eisenberg's mind, he was doing what the code allowed. As you mentioned, code is law. But will the courts look at things differently?
Right, and this is that intersection, as I say, where it will be interesting because you do see that very comfortable and open disclaimers and statements by people like Eisenberg and saying, I've done nothing wrong. This is arbitrage. This is just a good commercial move. I basically used the code in a way that I, outsmarted people, and I used it in a way that it permitted me to use it. But of course, it goes to that question of just because the code was drafted perhaps in a way it shouldn't have been, that permits it, does that mean that the function that he carried out was done in sort of in line with the expectations of people using that DAO platform and the DeFi transactions? So, that's where it will be interesting, and those arguments are often made in that online world are now going to be tested because, it's not as simple as you knew the risk and this is a result you could expect. There are questions about what the parties really have intended. Could they ever have intended this? And now he's going to have to make these arguments in a court of law. And to be frank, it's about time. I think we're all interested in seeing those arguments that proliferate online actually being made in a court, because we think there's going to be some big implications to that.
And you mentioned that this could have implications toward DAOs going forward, or what may some of those be?
Sure. And I think one of the big ones that come out are the implications if you get doxxed, right? If you, in Eisenberg's case, I mean, it's unusual to some extent and important because his name did go out there. If it doesn't, a lot of this becomes academic, right? But here he got doxxed, his name went out there, and he did have a message saying, it's just good arbitrage. Well, now that he's been outed, so to speak, it does raise that question of if you're doxxed, are you going to make these arguments now in the court of law? And now he doesn't have a choice in this case, but in certain cases, people may just flee. We've seen other situations where people do flee. They leave the jurisdiction, but now he's caught within it. So certainly implications if you get doxxed and now you have to deal with the real world of law enforcement, the Securities Exchange Commission, the Commodities Futures Exchange Trade Commission. So those real world realities now are crashing home. But I think it also has some really important and interesting implications for the settlements that are purported to be made when DAOs suffer these exploits. The bounties, for example. He had a record white hat bounty he negotiated with some of the principals of the DAO, and they had a vote on it, and they entered into that settlement. But right from the get-go, many lawyers, including myself, said openly, this is going to be a problem. The settlement's going to be challenged because there are some pretty straightforward problems with it. No, you can't promise not to file a criminal charge like they did in the settlement. No, a DAO likely can't bar its users from seeking relief in the courts, which it purported to do in the settlement. And no, a settlement under these conditions likely isn't enforceable. And now we're seeing Mango Labs bring that civil lawsuit. So we really think and hope that Mango's case, which really almost an ill-advised settlement or one that perhaps was doomed to fail from the beginning, it's going to put a real shock of reality into the DAO ecosystem. Because if you are doxxed and if you decide not to run and make the fight, and Eisenberg now is being brought home to have that fight, there's going to be a reality check because these kind of settlements are not likely to be enforceable by the courts. They're going to be challenged as they are here. And it makes you wonder next time around, is that exploiter going to stick around and try to make that deal?
Is there a way to make DAO settlements legally effective?
Well, there's a whole bunch of issues that are wrapped up into that. I think one of the interesting ones are, first, you have to talk about what the DAO is. In many situations, the DAO is just a collection of users, right? It's a community of users, perhaps with a core contributor doing the coding, but some of them don't even have a legal structure. Now, Mango Markets changed a bit. They have Mango Labs, so they have the entity, a Wisconsin limited liability company that can bring this lawsuit. So that changes things somewhat because you have an entity to actually bring the claim. But what if you didn't? There's a lot of DAOs out there that don't have that legal structure. Does it become a class action on behalf of the users to try to undo the settlement or to seek a remedy against the defendant? How do you do that? Do the core principals try to make some kind of efforts on its behalf? There's questions about what the DAO can really do, and it really goes to what is the DAO? Does it have a legal structure? Does it not? And we're seeing with Mango Labs, we're seeing with SushiSwap, we're seeing more entities starting to look at some form of LLC, limited liability structure, so that it can do things on its own. And I think that's going to be one of the interesting approaches is, are we going to see more of that in that legal construct so that they can act on its behalf and take steps on its behalf? But then you have a bigger problem because even if you resolve that issue, what constitutes agreement by the users, right? Does simply clicking on a vote for a proposal crafted by the principals of the DAO for a settlement, does that mean you've agreed to it and are bound by those terms and conditions? We saw issues of duress here in entering into this deal with Eisenberg. And now that's part of the argument that Mango Labs is saying. It was under duress. It wasn't a proper deal and settlement. It shouldn't be upheld. And there's a lot of reasons why there's good arguments in that regard. But can you bind the users and their own rights of action in a civil case? Can you bind that as a DAO and force everyone to do what you think you should do? So it raised a lot of interesting questions about settlement law, how you enter into it, what's a proper and binding settlement. And here, I think Eisenberg's got his work cut out for him because he's got a settlement that purports to do a lot of things, such as not file criminal charges, that a settlement just can't do in most areas of law.
Yeah, a lot more questions than answers so far, a lot of legal issues to work out. Benjamin, thank you so much for your time. That was McMillan partner Benjamin Bathgate.